Hi everyone. Um, this is about our politics. I'm not liking my camera view, so I'm gonna bring it down and bring it up a little bit, and we'll do it that way. Um, this is about our president. Yes, I'm calling him the president. I really don't call him the president, and that's my opinion, and I'm allowed that. But I want to show you what ex-president uh, Obama had to say. Hi, Matthew. Um, this is important. I've tried telling people that, you know, I might not be the smartest one, but I understand what's going on in it. I just can't say it. So I am going to show you a video. Thank you, Matthew. Um, let me see where we want to do this. Share screen. Okay. We're going to do this.
Right now, the United States is entering one of the most volatile and dangerous moments in its modern political history because two unprecedented forces are closing in on Donald Trump at the exact same time. On one side, impeachment articles in the House, 7 of them, are moving forward with charges ranging from obstruction to constitutional violations to outright tyranny. On the other side, federal judges are openly warning that Trump's repeated defiance of court orders could lead to criminal contempt, meaning jail time, not symbolic penalties, actual incarceration. This isn't speculation. This isn't media hype. This is the convergence of two branches of government, tightening pressure around a sitting president simultaneously, each building a legal case that could remove him from power or even confine him to a cell. The clock is ticking down. Trump's options are narrowing. The House has brought forward impeachment articles, 7 distinct counts, each one zeroing in on a different facet of Trump's purported wrongdoing. There's obstruction, there's the seizure of congressional prerogatives, there's trampling of constitutional protections, and there's the charge that stands out most starkly: tyranny. Yes, tyranny. The House of Representatives, exercising its formal constitutional powers, is charging the President of the United States with trying to impose tyrannical governance. That's not political name-calling. That's not sensationalized reporting. That is an official declaration, a juridical declaration, a declaration for the history books. As Congress advances toward impeachment, the judicial branch is ramping up its own confrontation.
I love it when I am going to stop it there. He goes into details of everything. Sorry that I stopped you in that point of the picture, but really listen to this. This is very much why we can't do a lot of things and why it is all now coming to a head.
Federal judges are no longer delivering warnings cloaked in diplomatic phrasing. They're drafting opinions that explicitly outline what comes next if Trump continues disregarding court directives. They're detailing in unambiguous terms the legal route from Trump's noncompliance to criminal contempt. And criminal contempt translates to imprisonment. Judges are making it crystal clear they possess the power to charge Trump, to penalize him, and if required, to put him behind bars. They're not conveying this quietly. They are describing the procedure in meticulous detail. They are laying the foundation. Envision the terrain: Congress inching toward impeachment, judges readying contempt determinations, and Trump stationed right in the middle as both branches converge. This is not a theoretical situation. This is unfolding right now. The apparatus has been set in motion.
About time.
The mechanisms are operating, and Trump is rapidly losing time to alter his trajectory. The trigger point that sparked the most recent judicial intensification involves Judge James Boasberg. He delivered.
Here's my point of the view. He has did all these court cases. Now stop and think about it. He's lost a lot of court cases. That is our money. I think he needs to get, we need to do like an invoice of all the money he owes the court system, our government, our money, for all these cases and that. I don't know if we're able to do something like that, but I honestly hope we can. Someone will figure it out. Because, we're talking millions and millions of dollars. I'd say close to billions how many cases he's lost. It's the last time 200 and some.
A very precise injunction. Asylum seekers were not to be removed from the country. He articulated it in court directives. He made it unequivocal. No room for interpretation. Do not deport these people. But the Trump administration proceeded and deported them regardless. They didn't seek clarification. They didn't postpone implementation. They didn't follow through. They resisted. They disregarded. They broke a direct federal court directive. When Boasberg discovered what had transpired, he didn't view it as a procedural error or administrative confusion. He characterized it as defiance, as contempt, and he declared that there was probable cause to hold the administration in criminal contempt. Probable cause is a judicial benchmark. It signifies there is sufficient evidence to suspect a crime might have been perpetrated. Boasberg established a time limit. Correct this, undo the violation, restore adherence, or contempt proceedings will commence. That's not an empty gesture. That's the judiciary engaging enforcement protocols. This violation wasn't an isolated incident. It was component of a persistent pattern. Judges throughout the nation have protested that Trump's administration operates as if court directives are discretionary recommendations instead of mandates. Researchers discovered that approximately 1/3 of significant judgments against the administration were ignored, postponed, or openly violated. Trump officials have dragged their feet on compliance, suppressed evidence, reintroduced block policies under different labels just to circumvent federal judgments. Judges are exasperated. They're indicating that the limit has been reached. They're making it apparent that if the administration continues defying court directives, they will deploy the complete authority of contempt, civil or criminal, to uphold the law. Civil contempt could mean enormous daily penalties, mounting until compliance is secured. Judges can levy those sanctions directly, no prosecutors necessary. Judges can even mandate imprisonment until court directives are followed. Criminal contempt is even more punishing. Criminal contempt regards the violation as a criminal offense punishable by penalties or imprisonment as retribution, not merely to compel compliance. Judges can forward criminal contempt to prosecutors. They can set in motion proceedings that result in trials, guilty verdicts, and incarceration. Here's the complication. Trump oversees the Justice Department, which means he could theoretically prevent criminal prosecutions against his own administration, but he cannot halt civil contempt. Judges can enforce civil penalties directly from their position, completely separate from the Justice Department. Trump cannot interfere, he cannot nullify it, he cannot impede it. And that is precisely what judges are now highlighting. Picture the situation developing. Congress advancing toward impeachment, judges preparing contempt measures, two branches of government enclosing around a president who cannot prevent either mechanism. Trump is being compressed politically, legally, structurally. This is not just a crisis. This is a convergence of crises. Let's examine more closely the impeachment articles so you grasp the seriousness of the charges. Representative Shri Thanadar submitted House Resolution 353 on April 28, 2025. That resolution contains 7 articles, each one a distinct constitutional accusation. Article 1, obstruction of justice and dereliction of duty. This charges Trump with breaching his constitutional obligations to enforce the law, honor separation of powers, and carry out the responsibilities of the presidency. Article 2, appropriation of Congress's spending authority. Congress exclusively controls federal expenditures. Yet Trump supposedly disbursed funds without congressional permission, an unconstitutional grab of legislative power. Article 3, misuse of war and trade powers. This article charges Trump with commanding military operations without congressional consent, again, seizing power the Constitution assigns to Congress. Article 4, infringement of First Amendment protections. This charge states Trump struck back against detractors, including judges and investigators, breaching safeguards for free expression and compromising judicial autonomy. Article 5 addresses something that most Americans seldom consider but is fundamentally essential to how government operates: the establishment of legitimate offices. The Constitution is unambiguous. Congress determines what positions exist within the federal government, not the president, not the executive apparatus. But according to this article, Trump established positions that Congress never sanctioned. He designated individuals to posts that were not legally created. In other words, the charge is that Trump invented offices from nothing to expand his personal power. That is a frontal attack on the separation of powers. Article 6 raises the stakes even more dramatically: bribery and corruption. This charge penetrates deeper than policy conflicts or political differences. It claims that Trump manipulated the authority of his office for personal gain, that he took bribes, that he wielded the presidency not to benefit the nation, but to benefit himself. And in the chronicle of impeachment, bribery has consistently been one of the most straightforward, definitive grounds for removal. When a president treats public authority as a personal enrichment scheme, the Constitution intervenes. And then arrives Article 7, the most incendiary charge of all: tyranny. This is not political rhetoric. This is not slander. This is a constitutional designation with constitutional significance. Tyranny is the exploitation of government authority for repressive ends. Tyranny is the effort to centralize power in one person at the cost of democracy, checks, and balances. The article claims that Trump's conduct reveals a deliberate intention to institute such governance, that he is purposefully weakening the constitutional framework, that he is dissolving democratic protections. In other words, that he's attempting to become a tyrant. Congress is not murmuring this. They are declaring it officially in an impeachment resolution, summoning the most severe terminology the founders bequeathed. These articles aren't merely political contentions. They're institutional accusations intended for the permanent record of American history. There's something additional about this impeachment resolution that you need to comprehend. It was submitted as a privileged resolution. That means it circumvents the standard procedural obstacles. It doesn't require the endorsement of party leadership. It doesn't require authorization from a committee. It doesn't require placement on some extended legislative schedule. A privileged resolution compels the House to respond. It activates the countdown to a vote. It places the question, impeach or not impeach, directly before the floor. Representative Thanedar submitted notice on May 13th, 2025, that he planned to advance this resolution. That move by itself initiated a legislative timer counting down unless leadership discovers a method to delay or obstruct it. And even that is not certain. A vote could arrive at any time, tomorrow, next week, next month, but imminently. The apparatus of impeachment is progressing forward, and Trump cannot halt that machinery. Even that political peril dims beside the judicial danger rapidly materializing on the opposite side. Judge James Boasberg's determination of probable cause for criminal contempt transmitted shockwaves through the legal world. And what's remarkable is how straightforward the fundamental facts are. Boasberg issued an injunction. He commanded the administration not to deport particular asylum seekers. He stated it plainly. He stated it unambiguously. A federal judge with constitutional power instructed the executive branch, do not do this, and the administration proceeded anyway. That action by itself, defying a legitimate court directive, triggers a constitutional warning. But when Boasberg reviewed the evidence, he didn't dismiss it. He didn't issue a caution. He didn't request additional explanation. He proceeded straight to the legal standard for criminal punishment, probable cause. That signifies he believes there is adequate evidence to warrant treating this as a potential criminal act. Boasberg didn't halt there. He provided the administration a time limit: remedy this, change direction, conform with the injunction, or the court will initiate contempt proceedings. That is a straight path from presidential defiance to potential incarceration for those accountable. The deportation incident isn't a singular error. It's component of a significantly wider pattern, a pattern that judges have been reporting for years.
I have to stop it right there. Do a commentary. You know, we've been fighting for this all year. You know, that's what the walks were about. Whatever. And the reason I'm letting him this play out is because there is no way I could understand. Well, I could repeat. I understand what he's talking about, but I can't repeat what he is saying. And he's so well spoken of a president. And I'm so proud of him. So proud that he was our president 2 times.
Washington Post examination discovered that Trump officials were charged with disregarding or evading 1/3 of major court judgments against them. Consider that. 1/3 of instances, a judge instructed the administration, you cannot do this. They proceeded anyway. Sometimes they delayed. Sometimes they concealed documents. Sometimes they reintroduced blocked policies under alternative labels.
Or did it?
But the message was identical.
Night.
The administration functioned as if court directives were voluntary. Judges have observed. Judges are exhausting their patience. And judges have begun outlining the ramifications in unmistakable language. Civil contempt grants judges the authority to levy daily penalties, substantial penalties that compound until compliance is reached. They can escalate those sanctions exponentially. They can target agencies, officials, administrators. They can even mandate imprisonment until the violation ceases. And here's the crucial point. Civil contempt does not necessitate prosecutors. Judges implement it directly. Criminal contempt regards the violation as a criminal deed punishable by imprisonment or penalties. Criminal contempt necessitates prosecution, but even there, judges can launch referrals. And while Trump might attempt to protect his administration from criminal prosecution because he oversees the Justice Department, he cannot protect them from civil contempt. Judges do not require the executive branch's participation. They do not require Trump's consent. They possess their own implementation authority. This is where the trap closes. Trump can disregard Congress. Trump can dismiss officials. Trump can delay investigations. But he cannot dismiss federal judges. He cannot nullify court penalties. He cannot stop judges from delivering contempt directives. He cannot prevent them from confining officials to jail for disobeying the law. And judges are communicating that they are on the verge. Enough is the sentiment surfacing from the judiciary. Enough with violations. Enough with defiance. Enough with the executive branch conducting itself as immune to the rule of law. The courts are establishing a boundary. If that boundary is violated again, contempt proceedings could initiate and imprisonment could ensue. Envision what transpires if multiple judges throughout the nation reach that threshold simultaneously. Envision concurrent contempt measures, one in Washington, one in California, one in New York. Envision officials across the executive branch being called, penalized, sanctioned, or imprisoned. That's not merely a crisis. That's a constitutional fracture. Because contempt isn't political. It isn't partisan. It's the judiciary implementing compliance when the executive branch declines. It's the system safeguarding itself from a presidency that considers itself above the law. This is why the convergence is so perilous for Trump. Congress advancing toward impeachment from one angle, judges preparing contempt from the other. Both branches functioning independently yet concurrently. Both branches asserting constitutional power against a president they consider as transgressing boundaries. Both branches intensifying pressure with no route for Trump to evade both at once. He is being trapped, pressured, encircled by institutional mechanisms designed to restrain presidents. And the velocity of that convergence is increasing. To comprehend the gravity of the moment, you have to perceive how these two crises, impeachment and contempt, are not just concurrent, but interconnected. Each one strengthens the other. Each one amplifies the consequences of the other. Congress charges Trump with tyranny, with exceeding his constitutional boundaries, with attempting to consolidate authority, and the judiciary is simultaneously recording Trump's methodical defiance of court power. Congress states Trump is trying to govern without constraint. Judges state Trump is conducting himself as if legal constraints don't pertain to him. Both branches are reaching the same determination from separate perspectives. and Trump is now caught between those determinations. When Congress charges a president with tyranny, it is not delivering a casual reproach. Tyranny is arguably the most grave constitutional charge conceivable. The founders inscribed the impeachment authority specifically to forestall tyrannical governance. They established checks and balances specifically to restrain it. For the House to charge the president with trying to institute tyrannical governance is to state in explicit constitutional language, the president of the United States is functioning like a dictator. The resolution clarifies that in their assessment, permitting Trump to stay in office constitutes an active danger to the Constitution itself. This isn't regarding one flawed judgment or one policy conflict. This is regarding a pattern, a direction that Congress considers jeopardizes the fundamental framework of American democracy. And they are preparing to respond. While Congress advances toward removal, the judiciary is advancing toward implementation. Judges are declaring, you cannot disregard our directives. Judges are declaring, you cannot regard the rule of law as voluntary. Judges are declaring, if you persist, we will exercise our authority up to and including imprisonment. Trump confronts the prospect of being removed by Congress and simultaneously facing imprisonment through contempt. Not in sequence, not one following the other, but concurrently. Reflect on that. We could reach a juncture where, as the Senate deliberates whether to remove Trump from office, federal judges are delivering directives for the arrest or detention of officials who broke injunctions. We could reach a juncture where Trump departs office under impeachment while members of his administration enter prison cells under contempt judgments. We could reach a juncture where constitutional branches clash in methods unseen since the Civil War period. This is not exaggeration. This is the situation that materializes when one branch charges a president with tyranny and another determines that the president is violating the law. Let's discuss why contempt is so threatening to Trump personally. Initially, contempt might appear like something aimed only at subordinate officials, the ones who implement directives rather than issue them. But that is not accurate. Judges can hold any official in contempt, including ones designated by the president, including ones answering directly to the Oval Office, including under certain interpretations, Trump himself, if the violation is sufficiently direct. And the essential point is this: Trump cannot step in. He cannot instruct judges, don't hold my people in contempt. He cannot terminate proceedings. He cannot command the Justice Department to rescue anyone from civil contempt because civil contempt circumvents the Justice Department completely. He cannot command the courts to withdraw. He cannot hinder contempt determinations. This signifies Trump could witness his officials being arrested while he remains president. He could witness judges levy million-dollar sanctions on his agencies. He could witness the judiciary eliminate his administration's capacity to function, and he would be unable to prevent it. That right there is where the authentic constitutional crisis exists. Because if Trump persists in defying court directives, judges will protect their power. They will protect the rule of law. They will protect the Constitution. And if Trump declines to surrender, the resulting confrontation between the executive and judicial branches could transform the limits of presidential authority for generations. Let's examine the schedule, because timing is critical here. On April 28th, 2025, Thanedar presented the impeachment resolution with 7 articles. On May 13th, he submitted notice to advance it as a privileged resolution. That signifies the House is now on a countdown to determine whether Trump should be impeached. On April 18th, 2025, Judge Boasberg delivered his determination of probable cause for contempt concerning the deportation violations. His time limit for compliance is already active, and that contempt is just one of numerous cases percolating in federal courts throughout the nation. Within weeks, potentially within days, 2 distinct constitutional processes could engage. Congress could vote to impeach Trump, judges could advance with contempt proceedings, and both could transpire in the same news cycle, the same 48 hours, perhaps even the same day. Picture watching cable news as the House votes on impeachment while a federal judge declares that contempt hearings will commence the next morning. Picture senators preparing for a trial while learning that high-ranking officials are being penalized $50,000 a day for declining to conform with federal injunctions. Picture the country confronting the possibility of a president removed from office while his administration faces legal ramifications so severe they could cripple executive operations. This convergence, the impeachment convergence and the contempt convergence, is the ultimate examination of the Constitution's strength. It poses one vital question. What transpires when a president attempts to remain above the law at the precise moment the other branches determined to implement the law? The founders constructed a system where no president could become a monarch. They constructed a system where Congress could remove a president for dangerous misuses of authority. They constructed a system where judges could compel presidents to follow the law, but they also recognized that if a president simultaneously defied Congress and the courts, the nation could confront a constitutional emergency. That is the moment we are now approaching. This complete crisis originated with something deceptively straightforward. A judge commanded that asylum seekers not be deported. The administration proceeded anyway. That violation sparked a legal reaction that revealed a much more profound problem: the persistent refusal of Trump's administration to comply with court judgments. And that refusal consequently gave credence to Congress's charge that Trump was functioning tyrannically. This is how constitutional crises develop, not with one explosive incident, but with a pattern of minor violations that accumulate and accumulate and accumulate until the other branches can no longer disregard them. The judiciary is preparing to respond. Congress is preparing to respond. And Trump is losing options. The House is advancing toward impeachment. Judges are advancing toward contempt. Trump is advancing toward a point where he must select conform with the law or collide with the Constitution. And thus far, every indication from his administration suggests that compliance is not the course they plan to pursue. The consequences could not be more significant. The country is observing. The world is observing. The system is being examined in methods it has never been examined before. And the result will establish whether the Constitution can endure a president who considers he is untouchable. What transpires if impeachment and contempt collide at the identical moment? What transpires if Congress moves to remove Trump at the same time federal judges move to punish Trump's administration through penalties, sanctions, or imprisonment? That situation isn't wild conjecture anymore. It's not a hypothetical. It's the direct, logical result of the paths both branches are already pursuing. Congress is promoting an impeachment resolution constructed on claims of constitutional violations and authoritarian conduct. Judges are recording rule breaking, delivering warnings, and preparing implementation measures. These forces are on the same trajectory, directed at the same objective, and accelerating toward the same conclusion. Congress states Trump is misusing authority, dismissing checks and balances, and compromising constitutional boundaries. Judges are simultaneously stating Trump is defying court directives, disregarding legal limits, and regarding the judiciary as powerless. Congress states Trump is attempting to govern like a tyrant. Judges state Trump is functioning as if he's above the law. Both branches are reaching the same determination that Trump's behavior is incompatible with constitutional governance. Here is the most hazardous component of the convergence. If Trump declines to conform once judges begin implementing contempt directives, the judiciary has the authority to intensify ramifications. Judges can mandate escalating penalties. Judges can mandate the confiscation of documents. Judges can mandate the designation of special masters. Judges can mandate the detention of officials. Judges can even refer matters to U.S. Marshals because contempt is not an advisory judgment, it's implementable law. Picture all of that developing at the same time the Senate is deliberating whether Trump should stay in office. Picture a president attempting to combat an impeachment trial while his administration is simultaneously being sanctioned, penalized, or imprisoned. Picture the disorder, picture the constitutional alarm, picture the political inferno. Trump could be impeached on a Tuesday and confront contempt judgments on a Wednesday. The House could vote to remove him on a Thursday while judges prepared detention directives for Friday. This is not a fantasy situation. It is the logical terminus of the two processes already advancing through Washington. And Trump recognizes it. That's why he's attacking judges. That's why he's challenging the legitimacy of impeachment. That's why he's depicting both branches as partisan adversaries rather than constitutional participants, because he recognizes these dangers are genuine. He recognizes the machinery is operating. He recognizes both branches are preparing to respond in methods he cannot completely control. Trump's inability to employ the Justice Department as a defense becomes vital here. Normally, Presidents who fear prosecution attempt to depend on the Justice Department to shield them, but civil contempt circumvents the department completely. Judges don't require prosecutors. Judges don't require indictments. Judges don't require grand juries. Civil contempt is an instrument the judiciary deploys directly. In criminal contempt, even if Trump attempts to obstruct it through the Justice Department, judges can still refer matters to external prosecutors or special counsels. They can still advance the legal process forward. Simply stated, Trump cannot employ his executive authority to halt judges from employing their judicial authority. That's what makes this moment unlike anything in contemporary history. Congress is applying pressure from above. Judges are applying pressure from below. And Trump discovers himself compressed between two immobile constitutional barriers. If Trump reacts to impeachment by intensifying his defiance of court directives, judges will regard that as additional evidence of tyranny. And if judges react with contempt judgments, Congress will regard that as additional justification for impeachment. Each branch's responses reinforce the legitimacy of the other's responses. Each branch's conclusions validate the other branch's apprehensions. This is a feedback mechanism, a constitutional vortex, a spiral of power closing in on the presidency. And Trump has no institutional instruments remaining to escape from it. If he dismisses officials who decline to violate court directives, he appears more tyrannical. If he encourages officials to break directives, contempt sanctions intensify. If he attacks judges, he reinforces the contention that he is breaching the First Amendment. If he attacks Congress, he strengthens the tyranny charge. Every action he takes accelerates the crisis. The founders constructed impeachment as a solution for high crimes and misdemeanors. They constructed contempt authorities to maintain the rule of law. They constructed checks and balances to forestall precisely this situation. A president trying to govern outside the parameters of constitutional power. And those mechanisms, impeachment and contempt, are now engaging simultaneously. The nightmare situation the system is attempting to prevent is a president who declines to obey court directives while also declining to acknowledge congressional supervision. A president who attempts to override both the judiciary and the legislature. A president who attempts to elevate his own power above all other branches. A president who functions as if the Constitution does not limit him. That is why Congress invoked the designation tyranny in its impeachment articles. Because tyranny is not characterized by explosions or armies or coups. Tyranny is characterized by the centralization of authority. Tyranny is characterized by the dissolution of limits. Tyranny is characterized by the refusal to follow constitutional boundaries, and that is what two branches now consider Trump is executing. Once contempt proceedings commence, once judges announce that the administration broke court directives and will confront sanctions, the executive branch enters crisis condition. Agencies must select whether to conform with judges or with Trump. Officials must select between obeying the law or obeying Trump's instructions, and Trump must select between intensifying conflict or retreating. If he intensifies, contempt amplifies. If contempt amplifies, impeachment gains momentum. If impeachment gains momentum, removal becomes more probable. If removal becomes more probable, Trump may strike out even more. And the spiral deepens. This is the moment where the Constitution is genuinely examined. Can the system endure? Can the rule of law succeed? Can a president be compelled to follow legal limits he is trying to dismantle? Those are not theoretical questions. Those are not historical hypotheticals. Those are the questions confronting the United States right now. As impeachment progresses and contempt threatens, the consequences could not be more significant. The result could influence American governance for decades. This is not just another segment in partisan conflict. This is a constitutional stress examination. The inescapable reality is that Trump is losing time, losing allies, and losing alternatives. Congress is preparing to respond. Judges are preparing to respond. The machinery is advancing forward on both fronts. This is the convergence. This is the final stage. The impeachment vote could transpire soon. The contempt judgments could transpire even sooner. And when both collide, when impeachment and contempt develop together, America will enter one of the most consequential constitutional confrontations since Watergate. Trump will confront removal. Trump will confront legal ramifications. Trump will confront the complete force of the system he spent years attempting to manipulate. And the world will observe to determine whether the Constitution can endure a president determined to shatter it.
Well, like I said to you guys, let me do this. Like I said, it was an educational one. And you learned about what and how it was to be done. Okay? And he said it very well. What is the procedure of it? Oh, Chris. You know, you and Paul should get together. You are two peas in the pod. I guess you came from the same stupid pod. But what can you say? Yeah, gas is down to $1.98, the president said tonight. You don't agree with everything with Trump? So you think it was fine him taking bribes? It's fine that he advertised on the White House. It's okay that he sold things from the White House, which all that is against our laws. The president is not to make money. And he was straight out making the money. You know, I'm not saying Democrats don't do it. I'm not saying that's not. But I can say one thing. He did it right out in front of everyone. But you want to continue with Trump? Like I said, I do not call him the honor of our country. No, Paul, I think you need to do better research. Why don't you go see on, was it Fox? He did that? It's not down to $1.98, but he said that on Fox. Out of his mouth. Even Fox doesn't want him on their show now. So, yeah. But if you want to come up here and discuss it, I'm willing to discuss it with you. But I know you won't. Here, let me see if I can figure out how to. There we go. Paul, would you like to come up? There's the link. Chris, do you want to come up? You regurgitate. You are in that cult that did that lemonade or Kool-Aid, you know? Oh, well, yeah. Well, you got the fingers to talk. You could talk to me through you there. But come on, man. Oh, you got a phone, right? You're using a phone. It has a camera. It has a mic. So don't lie to me. See, you're lying saying you don't have a camera or a mic. You lie. There's your excuse. So, cannot believe anything you say. You're on your computer. Well, yeah. Guess what? Computers come with cameras and mics. Oh, baby, 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 baby. Come on, Paul. You behind the excuse. You are not man enough to come up here. You are not, yes, sir. Most computers, monitors come with a camera on it. I just got a new, what is this, tower. And a new monitor. Camera. Mic. Speakers. Paul, don't lie. Sure. Come get to me. I'm in Pennsylvania. Come on. People like you, Paul, are not that bright. You lie, you lie, you lie. That's why you're a Trumper. And if anybody else is out there just they're going to come after me, then you're not as bright as you think you are. It's new computer, no camera or mic. Yes, it does come with computer. Oh, I know a lot about computers. I buy them all the time. But you do got your phone. Your phone has a camera. You can come up here on your phone. Oh, you're just a typewriter person. You just want to cause trouble. Yeah. The monitors have the built-in cameras and the mics. You're just not smart enough to know what you have there, what you bought. Or are you using a TV as your monitor? Yeah, this is a brand new one. This computer's a brand new one. Got the tower over here, monitor up here. They got camera and mic. That's what this is. This is a gaming computer. This is a gaming computer. So don't lie. Don't lie. My computer's a gamer. What else you got, excuse, Trumpy? Hey, Trumpy, what else you got to lie about? You're as good as Trump. See? You don't like to be called on when you're lying. Who wants to believe you? Yeah, what kind of baba do you want? Oh, well. I don't want to sit here and just talk to someone that doesn't have any intelligence. I do know, because I've had strokes in my brain, why I can't do a lot of things. But, oh, Paul, when you don't know your computer and your monitors, oh. Oh, Paul. What kind of monitor do you have? What kind of monitor do you have? Name your monitor. Acer. Yeah. Acer's has theirs built in. Did you connect it? Maybe you forgot to add the camera to everything. Ooh. A power spec computer. Okay. Yes. Yes, I know Acers do have the camera and the mic. He just don't know how to, turn them on. He didn't allow it. Like I said, let's see if I can get this. This is my computer. It's a gaming computer. You won't see the camera. Oh, I'll just do that. Oh, shoot. I can't get this thing to work right now. So I moved it. Oh, too far away. You would not see the camera. It's a little dot that's in the black. You won't see it unless you turn it on. I'm not a moron. I know Acers has it. Oh, my. You lie. Yeah. Okay, I'm going to go because, Paul was so dumb. He doesn't know anything. Acers do come with cameras. Mm-hmm. Yeah.
Hello. It's
Yeah.
me. It's me, Paul.
Mm-hmm.
I just want to let you know that you're right about all this. I'm just a big dummy. You're right, KK.
Yeah, Paul. I know who it is.
You're
Love you.
you're the best. I just want to let you know that I'm Paul and I'm a dummy.
Yeah,
I just
Paul
wanna let
Dummy. Yeah,
Yep,
Paul's
I'm just a
dummy.
big dummy. But you, KK, you're brilliant. Just want to let you know that.
Well, thank you, dear. Thank you.
Okay. All right. I'm gonna go to bed because it's past my bedtime, and also I like guys. So
Oh, yeah, Paul does like guys.
yeah, I
Yep.
do. I do.
He's
I do.
confused.
Oh no, I'm certain I do. Well, have a good night.
Night. Oh, my. Paul, see, I told you had a camera and mic. You lied to us. Look at that. You were just up here. Oh, Paul. But okay, everyone else, I hope you understood what could be going down and how it gets done. So, okay, good night, everybody. God bless you, and may you always be happy.